Hey everybody, so you have spent some time trying to match up Supreme Court cases with specific amendments in the Bill of Rights, and this video is going to explain the correct answers. So let's see how many you were able to get right on your own. So for the First Amendment, which guarantees the right to freedom of speech, freedom of religion, etc., that case is the Church of the Lukumi Babalu Ai versus the City of Hialeah in 1993. So in this particular case, this religious practice that involved killing chickens was a question of whether or not this violated the freedom of religion in the First Amendment. And the Supreme Court ruled that yes, this new law in Florida was unfairly targeting the Santeria faith, which would violate the First Amendment. So the First Amendment says that the United States government will not establish any religion, and so this particular law would have violated that by targeting a specific religion. And so this law restricting religious practice was tossed out in this case. The Second Amendment, this is one that has to do with the right to keep and bear arms. It does not come up very often in Supreme Court cases, which is surprising given how controversial this amendment can be sometimes. But in this case, all the way back to 1939 is United States versus Miller. So the right to keep and bear arms is the Second Amendment, and in this particular case, there were a couple of gangsters that were in possession of a sawed-off shotgun, and they argued that the Second Amendment protected their right to own this weapon. The Supreme Court said no, that this is not the type of weapon that is necessary for the maintenance of a well-regulated militia, which is what the Second Amendment actually refers to. And so therefore, this is not a right that's protected by the Second Amendment. So this is like one of the first indications of the types of weapons that the Second Amendment allows. And this is actually something that's going to be coming up in the Supreme Court in the next few weeks or months, a Supreme Court case involving the Second Amendment and the right to carry weapons. So there's a case coming out of New York, and so that's going to be an ongoing case where the Second Amendment is going to become an issue in front of the Supreme Court again. Okay, the Third Amendment. This one is also very rare for Supreme Court cases. It's the one that has to do with quartering soldiers. So back in 1982, this is the case of Engblom versus Carey. So in this particular case, there were a bunch of corrections officers that had gone on strike, and so this prison wasn't going to have the staffing that it needed to ensure that the inmates were being guarded, taken care of, kept safe, etc. And so the government responded by sending in National Guard members. And so in this particular Supreme Court case, the Supreme Court ruled that National Guard members are considered soldiers in the United States military. And so the Third Amendment would apply in this case, because even though the soldiers, the National Guardsmen, weren't sent to the corrections officers' actual homes, they were stationed within the corrections officers' employee housing. So basically, they were given a place to live from the prison. That itself constituted the quartering of soldiers in people's homes. And so this was a violation of the Third Amendment. And it's one of the few that Supreme Court cases that has to do with the Third Amendment, because this one is pretty straightforward and doesn't often come up in any current issues. The Fourth Amendment. This case is Brendlin versus California in 2007. So this is the Fourth Amendment. We saw this come up with Apple versus the FBI. The Fourth Amendment guarantees the right to protection from illegal searches and seizures of your property, and many now view it as the right to privacy. And in this particular case, there was a car that was pulled over, and one of the passengers in the car, Brendlin, He was detained, he was searched, he was, and some of his things were seized in a police search of a car. So Brenlin argued that he was just a passenger in the car, and therefore the police didn't have any right to search him. But in this case, the Supreme Court ruled that passengers, not just drivers and not just the things in the car, they are subject to search and seizure in the Fourth Amendment. So be careful whose car you are getting into, or who is getting into your car, because according to the Supreme Court, yes, passengers can be searched within a car as well. The Fifth Amendment, there's a lot in the Fifth Amendment. It addresses a lot of different things, but one of the most famous parts of it is this phrase that you might hear from time to time in movies and TV shows, etc., where people plead the Fifth. And so the Fifth Amendment case was Salinas versus Texas in 2013. So essentially, this one individual, he was a suspect in a crime, a homicide, and he wasn't arrested or anything, but he was brought in and interrogated by the police. And he was, very cooperative until the police asked a very specific question about the shell casings at the crime scene and whether or not they would match the weapons that he had at his home. And at that point, he just stopped answering the police's questions. So later down the road, he was arrested in this particular case, and he claimed that his Fifth Amendment rights had been violated because he had pleaded the Fifth, which is protection against self-incrimination. It essentially means that you don't have to be a witness against yourself. You don't have to provide any evidence in court that would potentially get you in trouble. And the Supreme Court said in this case that individuals must clearly claim their Fifth Amendment protection. They can't just stop talking. So if you want to protect yourself, if you believe that there's evidence that might be used against you, and the police are asking you questions, you can't just stop answering their questions. You have to clearly state, I claim my Fifth Amendment privilege, or I plead the Fifth. And that's what will ensure that that you do not have to incriminate yourself any further. The Sixth Amendment, this is the case of Smith versus Huey from way back in 1969. It has to do with the right to a speedy trial. So the purpose of this amendment is to make sure that courts can't hold you in prison for years and years and years waiting for your trial to begin. And in this particular case, this guy, he had been writing, asking for a court case, a court date, and they had simply refused to do so. I believe it was like 7 years before he finally heard, his case was heard in court. And the Supreme Court agreed that this was a violation of the Sixth Amendment because the state had not made what they call a good faith effort to give this individual a trial in a speedy and efficient manner. So they ruled that this was a violation of the Sixth Amendment. The Seventh Amendment, this one's a little bit complicated. It has to do with patent law. This one doesn't really come up a whole lot either, but this is the amendment that deals with the right to a jury trial. So this one was Markman versus Westview Instruments. It has to do with patent infringement. And essentially the Supreme Court just ruled that patent cases, because they're so technical, there's so much specific legal terminology, that the patent cases are something that judges have the authority in interpreting. They don't go to jury trials because the amount of technical language would be outside of like the understanding of a jury. But the Seventh Amendment is the one that protects individuals and guarantees the right to a jury trial. All right, so then the last one here, the Eighth Amendment, Madison versus Alabama. This one's from 2019, so this is a relatively recent case. And the Eighth Amendment is the one that guarantees against cruel and unusual punishment. And oftentimes this comes up in the United States over the issue of capital punishment or the death penalty. So in this particular case, the individual in question, Madison, he had been in prison and had suffered a series of strokes, and he was unable to remember what he had done. And so he was arguing that the death penalty was a form of cruel or unusual punishment because how could he be punished for a crime that he couldn't even remember committing? But the Supreme Court had kind of an interesting ruling in this case. They said that that the death penalty is not necessarily cruel and unusual punishment just because you can't remember committing a particular crime. It would be, however, it would be cruel and unusual if an individual cannot rationally understand the reason for execution. So if cognitively they are unable to put the actions and consequences together and understand why they're being punished for a particular action or crime, then they cannot be given the death penalty. That would be a form of cruel and unusual punishment. So those are court cases involving Amendments 1 through 8 in the Constitution. How'd you do? Did you get all 8 right? If you did, fantastic work. If not, hopefully this video helps you understand why each of these cases matches up with Amendments 1 through 8. Great job.